Good afternoon. Our nation is dealing with a very new, complex, and emotional issue: how to balance the expectations of privacy and equality in one of the most private areas of our lives: restrooms, locker rooms, or public shower facilities. This was not a North Carolina state agenda. No one in North Carolina was talking about bathroom policy until the Charlotte City Council imposed a mandate on private businesses. This mandate required, with potential penalty of fine, access to restrooms, locker rooms, or shower facilities be based upon one's gender identity or gender expression. A similar policy was rejected just months earlier by the voters of Houston, Texas, by 61% of the vote. This caused major privacy concerns about males entering female facilities or females entering male facilities. Our state legislature believed this was an unnecessary government overreach into the private sector, imposing regulations and impacting one's personal privacy. The state legislature and this governor also believed that guidelines then needed to be put in place because of this new public topic for government buildings, our schools, and our rest stops to ensure privacy and expectation privacy for everyone. Now, just 5 days ago, the U.S. Department of Justice sent letters to my office, the Department of Public Safety, which reports to this governor, and to the university system, suggesting that having government employees use the bathroom, locker room, or shower facility that corresponds to their biological sex is in conflict with federal policy. The Department of Justice asked all parties to set aside their constitutional duty and refuse to follow or enforce our state law. This was a substantial request with very serious implications, and the U.S. government gave us a mere 3 business days to respond to this letter. We asked on Friday the Department of Justice for additional time. In fact, we asked for an additional 2 weeks, but they refused unless I made a statement where I would publicly agree with their interpretation of federal law, and if I did, they would give me 1 additional week to respond. I could not agree to that because I do not agree with their interpretation of federal law. That is why this morning I have asked a federal court to clarify what the law actually is. Now, I anticipate our own legislature, other private sector entities from throughout the United States, and possibly other states to join us in seeking this clarification, because this is not just a North Carolina issue. This is now a national issue, and an issue which imposes new law on every private sector employer throughout the United States of America with over 15 employees. We believe a court, rather than a federal agency, should tell our state, our nation, and employers across the country what the law requires. And let me say something. Our nation is one nation, especially when it comes to fighting discrimination, which I support wholeheartedly. Ultimately, I think it's time for the U.S. Congress to bring clarity to our national anti-discrimination provisions under Title VII and Title IX. Let me repeat that one more time to all of our U.S. representatives and the leaders of both the Republican and Democratic parties in Congress. Ultimately, I think it's time for the U.S. Congress to bring clarity to our national anti-discrimination provisions under Title VII and Title IX. Now, right now, the Obama administration is bypassing Congress by attempting to rewrite the law and set basic restroom policies, locker room policies, and even shower policies for public and private employers across the country, not just North Carolina. Now, I'm still asking the North Carolina legislature to reinstate the ability to sue for wrongful termination for discrimination in state court. I encourage them to do this and do it quickly. I also welcome additional dialogue with the City of Charlotte and our state legislature, which has been ongoing for the past week. And I want to ensure the people of our state and our country that North Carolina has long held traditions of ensuring equality. The majority of our citizens in our great state and this governor did not seek out this issue. However, the state of North Carolina and this governor welcome the opportunity to be part of the solution for all of the states and especially our nation, the greatest nation, the United States of America. Thank you very much.
The question that was just asked of me was, why was a claim under Title IX not asserted in this lawsuit? And the answer to that is, the Title IX issue was raised against the university system, not directed towards the governor, nor was it directed towards the Department of Public Safety. Those are the two claims that we addressed in our lawsuit. The university system will make their own decisions about what they want to do with that Title IX issue.
Quick follow-up. Are you,
Sure.
as far as you know, on board with UNC?
Do not know. My understanding is the Board of Governors is meeting tomorrow, and my assumption is they will take that up then and make a decision.
Mr. Stevens, some have said that the Fourth Circuit Court of Appeals has already weighed in on this in their judgment in the Virginia case.
In the Grimm case. Mm-hmm.
Yes, so what would you, I mean, do we need further clarification, or have they already made their
They have not. They have not, and it's important to note that. What happened in the Fourth Circuit case, a split panel, 2-to-1, made a decision that the district court, the lower court, had used the wrong evidentiary standard in deciding the case. And that split panel was to send the decision back to the district court to have the trial over again. So no mandate was issued to the district court. The district court has not conducted any further proceedings. And until that happens, it is not the law in the federal court, nor is the law in North Carolina. Second, we now know that the defendants in that case have petitioned the Fourth Circuit for a hearing en banc, which just simply means a hearing before the full Fourth Circuit, all 15 judges. That petition was filed, that stayed everything up to this point. The Fourth Circuit has not yet ruled on that. But until the Fourth Circuit rules, that's not the law of North Carolina. And in fact, what you'll see in our complaint is there is no law in North Carolina that answers some of the questions that we are raising. That's why we've gone to the court to try to get them to get the court to do it.
Mr. Stevens, how much will this cost to the state of North Carolina?
I can't tell you. I can't give you even an estimate. That's going to depend on what the other side does in this case. I was a litigator for 40 years before I became the governor's general counsel, and I learned early on you can't really anticipate what's going to happen. We believe that this should be decided on motions. We believe it should be decided very quickly, and we believe it and hope that it'll be decided very inexpensively.
Mr. Stevens, is there any common ground that the state has with the Department of Justice that could possibly avoid a long court battle?
Well, we'll certainly see that. We'll have to see if that's what happens. Right now, we simply have a letter from them that says our statute, which we commonly refer to as HB 2, violates Title VII.
So as of right now, there is no base thing that you and the DOJ agree with?
We have had no conversation, so the answer to your question is yes, there's no basis to believe that.
How does this suit impact that deadline at 5 o'clock?
This is our response to that deadline.
But because of that deadline, I mean, there could still be actions or consequences. How do you get around
There could be what? I'm sorry.
consequences from the DOJ standpoint? So,
Well, we'll see. We'll see what happens, but this is our response, so we've met the deadline, and now we'll go forward.
You
Folks,
talked
we'll
about
take
a
two more
possible-
questions.
You talked about a timeline, so very quickly, can you give an estimate, are we talking months?
Again, I'd like to be able to dust off my crystal ball and answer all these questions with specificity for you. I suspect it may be more than months, but we really hope to expedite this thing. We've asked for a declaratory judgment. I don't need to get into the weeds about what that means, but in law, declaratory judgment actions are given preference. So we hope that we will get this in front of the court and have it decided very quickly.
Mr. Stevens, this started out with an local ordinance at the city level, then the state came in and told the city that they're wrong. Now the federal government's coming in and telling the state that the state is wrong. What do you make of that parallel?
Well, first place, when you say it's the federal government, remember, this is a letter. This is a letter from the Department of Justice that says we have violated Title VII. As the governor said, Title VII, well, let me back up. We have specifically not violated Title VII, and if the Justice Department believes that we have, then they're going to need to go back to Congress and get Congress to change the law. Because right now, in spite of what this letter says to us, the class of people that the Justice Department are referring to are not a protected class under Title VII. And until Congress changes that, that's the law. Our bill, therefore, doesn't violate that.